Welcome to Transnational Competition Law course. And dear learner, I am going to deliver my lecture on enforcement of extraterritorial application of competition law in developing countries. Dear learner and viewer, you might recall my previous lecture on the same theme, wherein I discuss in a very detailed manner the competition law enforcement, the practical problems and hurdles and hiccups in translating the lofty ideals of the competition law in developing countries. And we got down and deep into that what are those factors which are responsible for the poor or feeble enforcement and ineffective regulation of competition law in developing countries. We have taken note in the previous lecture that competition law enforcement in matters of extraterritorial jurisdiction has addressed transnational violation of competition law that causes deleterious impact and harm all the market and the economic in the global level. We also took note, and you might recapitulate, that how the competition law, which has been put into promulgation, have safeguarded domestic market and developed capacity building among all the countries in inbound anti competitive harm. We also discuss in details that what happens to be the experiences, whether that may be wise or sordid, among developing countries in reviewing the offshore merger, restrictive agreement, cartel, and addressing the gamut of the cross border competitive conduct. We also discuss the plethora of the rules, regulations, and particularism and universalism of competition law enforcement among the developing countries, especially in reference to the labyrinth of the procedural rules, the intricacies of corroboration of evidence, collection, adducement of auxiliary facts, the issues of the non compliance, the gravity of the political pressures, and what are the collaborative efforts which have been undertaken by the developing countries in relations to diplomatic and as well as trust building exercise or confidence building exercise to see that the competition law in developing country should not remain only an ideal but it becomes practical and real. We in the previous lecture also dwelled on the issue of the enforcement experiences, especially taking note of a very brilliant survey which has been conducted by John M. Connor in his article, The Private International Cartel Dataset Guide and Summary Statistics, which encompasses a study of 26 years, meaning thereby from 1990 to 2060. In reference to John M. Connor's article on dataset guide and summary statistics of last 25 years, last 26 years, or almost of 3 decades, we have underlined very successfully that what are the significant practical experiences of the developing country, in fostering intrinsic cross border transfer enforcement against any kind of transnational anti competitive conduct. We also delineated very clearly as to what the developing countries have encountered in case of the review of the merger from an investigatory perspective and its ripple effect on anti-competitive effect of any kind of an offshore transactions. We also refer in the last lecture on transnational enforcement of transnational comp- application of competition law in developing country. We have very nicely tried to weigh pros and cons of the experiences relating to restrictive agreements in Brazil, Chile, China, Colombia, India, Kenya, Malaysia, Mexico, Pakistan, Peru, Russian Federation, Serbia, South Africa, and Turkey. In this context, we try to be very succinct and very brief in the sense that we have not taken the catena of all the cases which tries to give a kind of a feeling that what are the major hurdles and hiccups in translating the competition law in the developing country during the last 3 decades, but as a pilot a study or a test case, we referred to jurisdictional issues of India and South Africa in the context of United States American soda ash export cartel, shortly known as ANSEC judgment on anti-competitive conduct, export of cartel, which is being challenged both in Indian and as well as South African and European Union courts of justice. We refer to Indian decision of the Manufacturer Association of India versus American Natural Soda Ash Corporation, which was handed on in 1998, and realize this basic fact that how the absence of any competition law in any country makes the entire domestic market very vulnerable in matters of regulation of competition, anti competitive practices, merger and amalgamations, and abuse of dominance. We also referred the case of Haridas Export versus All India Float Glass Manufacturer Associations of 2002 by the Indian Supreme Court to convey this feeling and the message that how the desideratum of the competition law, for that matter, India or South Africa or any country in the world, happens to be a stumbling block in creating a very cohesive and robust market situation at the global level. We also refer that how the Indian courts experiences of anti-competitive practices and the conduct of the multinational corporation has deleterious impact, or in the words of Indian competition law, the appreciable effect which the Indian competition law uses the word appreciable effect on the market than that of the effect doctrine of the US antitrust law or the single unit doctrine of the European Union and the implementation doctrine of the European Union, the Indian competition law have chosen a very novel word that is neither the effect nor the deleterious impact, but it uses the word appreciable effect under its Indian competition law. And we also have referred to the expansive interpretation of Article 32 of the Competition Act, which was not originally conceived but inserted in 2003 by way of an amendment because of the experiences of Indian courts in relation to anti competitive practices and the conduct which are collusive in nature, and has given a categorical mention about the extraterritorial jurisdiction or transnational application of competition law in India. We also referred South African court's judgment, especially the judgment of Supreme Court of Appeal of South Africa in relation to the case which has been the source of agitation in India, European Union, and as well as in South Africa, United States, American soda ash export cartel. Anti competitive conduct was also brought in question and attracted the attention of South African Competition Law Authority vis-a-vis the Supreme Court of Appeal of South Africa on the complaint initiated by the Botswanan competitor in 1999. And the case has a history of 9 years of litigation, wherein the Justice Madlanga have rightly observed that this judgment represents a Methuselah of proceeding, which means that it has been one of the longest commercial law proceeding in the Court of Appeal of Supreme Court of Appeal of South Africa, and ultimately the judgment ended with in the favor of South Africa by imposing a substantial and exorbitant fine on the United States and some kind of a settlement on pecuniary basis wound up the entire case of what is called is the American Natural Soda Ash Corporation case. With this, dear learner, having recapitulated my lecture on the enforcement issues of the extraterritorial application of competition law in developing countries, we will be taking some very nice and novel examples besides the India, European Union, United States, and South Africa. We will switch over to some of the practical problems which are being encountered in South American countries. And in this context, dear learner, we'll be referring to the countries like Mexico, countries like Brazil, countries like Chile. And these three countries are to be taken as a test case to examine that how well that enforcement of transnational application or the extraterritorial application of competition law happens to steal the march in South American countries. The first transnational anti competitive conduct case in South America was initiated as far back in 1996 in Mexico, especially in case of Elazin cartel. And in 1998, the Mexican authorities found two firms, ADM and Coyoa, which happens to be very active in Mexican market, have committed the breach of law. And after a successful follow on the enforcement, what we find that it resulted into an effective enforcement of the extraterritorial application of competition law. Secondly, in case of a Brazil which initiated a law in 1999, and in case relating to the international vitamin cartel, the Brazil and filed case against the European Union in the United States, and the Brazilian competition agency known as CADE, in its own language, that it has been abbreviated, has commendably done for the imposition of the fines to the foreign perpetrators Hoffman La Roque and BASF and Aventis in 2007 in a case popularly known as International Vitamin Cartel. Then we find some inputs from the country like Chile, and the Chilean authorities in counter of the enforcement issues of extraterritorial application of competition law. And we find that the Chilean authorities have very successfully launched investigation regarding international refrigeration compressor and the issue of cartelization of refrigeration compressor in a famous Whirlpool case in 2002. So, in a way, we see that what transpired in the South American countries of like Mexico, Brazil, and the Chile, that many of the anti-competitive practices, abuse of dominance, the cartel, the predatory pricing, price fixing, and regulation of combination and merger issue have been settled. As we refer to the document of John Conan, we can reasonably say that what has been the pithy and substantive finding of the article of John M. Connor, on the basis of that, it has been revealed in a very startling manner that 97% of the sales of the product on the Chilean market happens to be responsible in one way or the other, affecting some of the issues of the competition law enforcement in extraterritorial context. Thus, what we find that the competition tribunal, either in whether it is Brazil or Chile or the Mexico, have led jurisdiction principle and have a judicial interpretation despite the absence of any explicit statute on the issue of extraterritorial and transnational application of competition law, has delivered its judgment. Then we will be dealing with the hurdles and hiccups which are in the way of the effective enforcement of the competition law in extraterritorial context, and then we will try to, dear learner, identify those hurdles and hiccups, because that is something of a seminal importance to see that how the laws are to be met with great success. The purpose of the law is not to see that it is observed more in breach, but the purpose of the law is to see that how it reaches to its compliance and enforcement. And for that end, we have to identify the hurdles and hiccups in case of enforcement of extraterritorial application of competition law. And then we have to identify the enforcement in developing country and locate the deficiencies in current global regulatory framework and all national competition agencies in relation to its procedural labyrinth and the procedural rules and regulation, evidentiary values, and issue of non-compliance, as well as the issue of non-cooperation in the investigation process, in the presence of the entire corpus of international competition law, comparative competition law, and the national or the domestic competition law, an instrument vis-a-vis the kind of the responses and the precedent, the judicial responses and the judgment, not only in matters of imposing of the fines, but having a clear cut kind of a precedent which can have a deterrent effect and have a salutary impact on the stages of investigation and the entire chain of the enforcement and the application of the procedural rules more in a generic sense of the term than any kind of a specialized or a cabin concept or a myopic perception of the enforcement. Then we will dwell, dear learner, on the issue of the Brazilian experiences as a separate heading, because what we feel that among the South American countries, the Brazil deserves to be applauded in the sense that the Brazilian competition authority and enforcement, popularly known as CAT, have been very actively involved in transnational launching of the cases where they feel there has been that misconduct and it has potentially affected the Brazilian jurisdiction, and the Brazilian CAD happens to encounter a large number of the cartel investigation right from 2010 to 2017. Half of the investigation pertaining to cartelization still remain pending despite the expeditious disposal of those disputes by the CAD. So is the example of right from the South American countries, we can go to the West Asia, and one of the most important and progressive country in the West Asia happens to be Turkey, or the Turkiya in modern parlance, or the use of or the currency. Then we see that the Turkey has also reported a good number of cases of anti-competitive prices on coal import, examining both on domestic cartelization and as well as what you can say is relating to the import and export from the European Union, because the Turkiya is considered to be Turkey, or the Turkiya is considered to be at the gateway of the Europe. The Turkish agency has been very successfully adjudicated large number of dispute and settle it. Now we can go to the another example of a country known as Colombian competition authorities, and what we find that the Colombian authorities have also dealt a large number of extraterritorial application of competition law disputes in a very amicable manner, and the first transnational case related to a thorough investigation of auto parts cartel, and which eventually resulted in the termination of the proceeding due to both ineffective service and the process and the procedural flaws and error.